How do you stop an epidemic? Today you're going to find out from one of the great lawyers that actually did it. Every trial lawyer has that one case, the one that pushed them to the edge, changed how they practice, or kept them up at night. This is Trial War Stories, and I'm your host, Andy Goldwasser. I sit down with great trial lawyers to unpack unforgettable cases, the strategy, the chaos, the pressure, and the moments that turn the tide beyond the transcripts and verdicts. And now to the show. I am so excited to have as my guest today, Peter Weinberger. Peter, thank you for joining. Peter is just an absolutely incredible lawyer. Welcome to the show.
Thank you. Great being with you, Andy.
Yeah, it's great to have you. And I was saying to our producer and Quenna this morning that this is one of those episodes that I think may be the most exciting episode for me to talk about. Because we are always talking about these single events, which is what we as lawyers mostly do, right? We represent a single client in connection with a single matter. What we're going to be talking about today is the opioid trial, which was the largest case in Ohio history and one of the nation's most complex cases ever that affected just thousands of people. There were thousands of so-called clients in the case, and it was just such an important case. So, Peter, can you share with us a little bit about how you got involved in this litigation and what it's about?
Sure. Andy, as you know, our firm, and that includes me, have been involved in handling medical malpractice and product liability and catastrophic injury cases. And dating back to Craig Spangenberg, we actually started handling what we call mass tort cases with the thalidomide children. That's back when I was in law school back 50 years ago. And so over the years, we've been involved in a lot of mass torts. And I was involved in one before Judge Polster that involved the dye that you use for MRIs. Gadolinium-based contrast agents that caused severe injuries to people with end-stage renal disease. And so he had a mass tort case that was assigned that case by the federal panel that assigns these cases to be consolidated before one judge. We finished that case about 12 or 13 years ago, and back in 2017, just as I was slowing down and gave up the reins as managing partner, I got a call from a bunch of lawyers around the country saying it looked like Judge Polster was going to be handling the multi-district case involving the opioid epidemic. And they knew that I had had a connection with the court involved in that other case. And they asked me if I would be, quote unquote, one of the leaders and specifically the liaison counsel. So the liaison counsel is the person that sort of helps organize the plaintiff's lawyers, corresponds and communicates with the defense lawyers, and most importantly, communicates with the court on with respect to status conferences and discovery disputes. And so sure enough, in early 2018, 21 firms organized their cases that they had filed on behalf of cities and counties around the country, about 3,000 of them, and they got consolidated before Judge Polster. I became the liaison counsel and one of the co-leads in the case, and things proceeded from there. I told my wife, by the way, I told my wife this was going to last 3 years, no more, and here we are in our 8th year, going into our 9th year.
Of course, but you've done such great work. It's worth it. So I just want to explain for our listeners who might not understand what we call the MDL or the multi-district litigation process. When there is a case involving a mass injury or mass event, that causes a lot of harm, it doesn't make sense to have hundreds or thousands of cases filed all over the country where the same against the same defendant, where the same people would have to have their deposition taken 1,000 times, or the same documents would have to be produced 1,000 times. So there's a process where these cases can be consolidated before one judge in a uniform way to handle as a consolidated proceeding. Did I explain that correctly, the multi-district litigation process?
Yes, and some people confuse it with a class action. It's not a class action, it's individual cases. Usually individual cases with individual injuries, particularly in the personal injury field, they don't lend themselves to class action cases. They have to be filed on an individual basis. In this case, we weren't talking about individuals. We were talking about cities and counties who sustained severe economic losses dealing with the opioid epidemic. Now, the indirect effect of that, or really the direct effect, is to help people, to provide for a remedy so that there would be addiction treatment centers, that there would be foster homes that would take care of the kids of parents who were addicted, that would help the judicial system who had drug courts, and would help emergency medical services to have Narcan, to be able to treat people with overdoses. So that's the kind of case that was brought around the country that got consolidated before Judge Polster.
Yeah, and I think when most people hear for the first time, oh, the opioid litigation, I think they automatically think, well, it must be for people who were actually injured by an opioid pill or killed or something to that effect. But here, that's not who you and the other lawyers were representing. You were representing municipalities, cities, and counties. Why is that, Peter?
So, as a firm, we looked at individual injury and death cases involving opioid overdoses. And the problem that we had was in tracing what was the cause. So a person might take an OxyContin pill prescribed by a doctor and ultimately become addicted, but the addiction doesn't necessarily, or the death doesn't necessarily occur because of the prescription opioids, but the person transitions from, prescription opioids to street drugs, has lots of other problems, perhaps uses heroin, uses cocaine, uses street fentanyl, and ultimately dies or suffers severe addiction. So the problem of causation in the individual case is enormous. We, on the other hand, took this sort of aggregated approach. So we were able to look at data of prescription dispensing across the country, and we were able to prove not only general causation, but specific causation in terms of the conduct of the defendants and their failures, and their causing the public nuisance. And so that was the best way we could figure out on how to provide a remedy that ultimately benefited the citizens of our country.
And that's really the key here. I mean, when you went to the court in a case like this, you had to come to realize that really the cause of these deaths and these injuries was from the massive amount of opioids that were being distributed across the country and dispensed from different pharmacies or prescribed by different doctors or these pill mills and those kinds of things. So how do you use the court and the judiciary to make a difference? Right? It's not by handling these single event cases. It's really bringing the claims on behalf of the municipalities to try to bring change. And I think that's ultimately what you and your team were so successful in doing. But let me take a step back for a moment. Can you tell us about, and I know it's massive litigation, but can you do your best just to tell us about the case, what your theories were, why you had those theories, and how the case progressed?
Sure. So it started with the Purdue story, which pretty much everybody knows about because there have been movies and books written about the Sacklers in Purdue. So they came up with this drug called OxyContin in the mid-1990s to replace morphine, MS-Contin, because MS-Contin had, was known to be highly addictive. It contained morphine. As it turns out, this molecule, oxycodone, comes from the same opioid plant, and it's manipulated to act just like morphine in terms of treating pain. But it is highly addictive. It affects the part of the brain that the pleasure center, and it latches onto it, and the addiction that's caused from that is actually worse than morphine. It's 2.5 times the strength of morphine. So they came up with this idea of marketing through sales reps to doctors. And they used fraudulent literature claiming that because they had developed this continuous release pill known as OxyContin, that they could keep the blood level uniform throughout the day, and that somehow that would prevent addiction. And they sold the doctors on this. They duped the doctors. There's actually a book about how the doctors were duped, written by one of our experts who was an addiction expert from Stanford. They duped the government. They duped the FDA. And these claims that were not scientifically based, that this was not addictive, was absolutely false. Ultimately, Purdue was convicted in 2007 and 8, and then again in 2018, they went into bankruptcy, and that's a whole nother story. They were a privately held corporation. The Sacklers took out about $15 to $16 billion as a family out of the corporation just from OxyContin. But they needed the distributors. There's 3 main distributors: McKesson, Cardinal Health, and AmerisourceBergen. And they needed the pharmacies to be on board. Now, the distributors and the pharmacies have an obligation under the Controlled Substances Act to ensure that there are effective controls over drugs like OxyContin and other opioids. They have a duty to make sure that if there are suspicious orders or if there are red flags associated with a particular prescription, that they monitor it and they stop the distribution and they stop the dispensing. So the bottom line is we use the Controlled Substances Act as our claim, as our rules of conduct, in order to then prove the public nuisance case, which is very simply when a defendant intentionally or unlawfully creates a danger to the community or affects the safety of the community residents, they are liable for that public nuisance. And in this case, they were held liable in various cases and in our trial, particularly the pharmacies, for creating the public nuisance, which was the opioid epidemic.
So I have a number of questions that I want to ask you. My first question is, if there's this Controlled Substance Act and it's up to really the government to supervise the distribution and the dispensing of this medication, why didn't the DEA or some other organization come in and stop the problem?
So the DEA, like a lot of federal agencies, including the FDA, have limited resources. And the fact is, Andy, in 2007, Joe Ranazisi, who was the head of diversion control and was the whistleblower in this case and was the 60-minute whistleblower and was one of our experts, he wrote a letter, several letters, to every registrant under the Controlled Substances Act, the manufacturers, the distributors, and the dispensers, and said, look, as of 2007, we have a huge problem. we have a growing epidemic, and you have responsibilities under the Controlled Substances Act to look for suspicious orders by pharmacies, that is to say the distributors and manufacturers. And at the pharmacy level, you have a duty to look for red flags. And you have to set up systems to do that. And we're going to monitor those systems, and we're going to monitor the suspicious orders. Well, that worked for about a month or two, but there was so much money being made in the distribution and dispensing of opioids because these defendants had changed the whole paradigm of treating pain. That the pain levels that are measured in hospitals, from 1 to 10, that started with Purdue. That started with Purdue going to the hospital associations and saying we need to make this our fifth vital sign, and nobody should be discharged from the hospital with a level of pain above 5. And if you get discharged, the government would actually, with a pain level higher than that, it would actually affect the reimbursement. So it was a huge problem created by big pharma, and so our job, Andy, getting back to the case, sorry for being on my soapbox.
No, it's important. It's really important information.
Our job was to use the judicial system, what the other two branches of government were incapable of doing, that is to provide a remedy to our society for what had happened in terms of the creation of this epidemic.
And that's just such an amazing part that I don't think most people appreciate about lawyers, especially in this mass tort world, because they see all this advertising and they think that the lawyers are chasing down these cases. Here, you're doing something, your team, and the group of lawyers who are taking just tremendous risk to pursue this litigation. You're doing it to fix an epidemic because the other parts of our government have failed to do so. And it takes a really brave group of lawyers to do that. Peter, let's turn to the case itself. So this podcast is about trials. So I know that you were liaison counsel in the case, one of the co-leads. You were also co-lead trial counsel. Can you tell us about the first trial involving opioid litigation?
So in 2021, November of 2021, we tried the case involving the CVS, Walgreens, and Walmart. It was a bellwether case involving Lake and Trumbull counties. It was selected in a selection process with the defendants. By that time, we had settled with the distributors and with the manufacturers. We actually started a distributor trial in November of 2019, Mark Lanier and I. That got settled at the courthouse door after jury selection, and then we ended up in a global settlement with the distributors and with J&J that was about $24 billion distributed across the country.
Incredible.
But the pharmacies decided that they wanted to go to trial. And so we started trial in November of 2021, Mark Lanier and I, against CVS, Walgreens, and Walmart.
Hey, Peter, I have to stop you for a second. So your clients in that bellwether case, just the bellwether case, which is the first one that you're trying, are Lake and Trumbull counties? Are those your clients? And the defendants are who?
CVS, Walgreens, and Walmart.
The big three.
The big three.
Okay.
CVS and Walgreens, we were able to, by the way, backtracking for just a second, every pill is recorded in what's called the ARCOS data of the DEA. So every time a manufacturer manufactures a pill, they have to report that to the DEA. Every time the distributor receives a pill, they have to report it to the DEA. Every time a pharmacy receives a pill from a distributor, they have to report it to the DEA. And so we have this huge database so that we can tell in Lake and Trumbull counties, for example, how many pills were distributed and dispensed every day of every month of every year between 2006 and 2014.
Incredible.
So we use that data to determine market share. What was the responsibility in terms of creating the prescription opioid market in Lake and Trumbull County. And we could actually compute on a per capita basis how many pills per capita were dispensed within the county. So we use that to prove, you talked earlier about the increasing volume of pills causing the epidemic. We know that with respect to opioids and other controlled substances, the higher the volume, the more likely it is that the pills are getting diverted into the hands of people for which it was not properly prescribed. We know that it causes diversion because of bad doctors who shouldn't be prescribing it in the first place. And so that data, that aggregate data that we used, was really important to prove the case. So Lake and Trumbull were the test cases. They both have populations of about 200,000 people each. The per capita opioid pills over those 8 years was about 40 to 50 OxyContin pills per year, per capita, for every man, woman, and child within the county.
That is astounding. I mean, you talk about an epidemic. That what you just described proves that there's a problem.
Right.
So tell us about the trial. How did it come together? What was it about? What was your role? Tell us about it.
Sure. Well, I had the honor of trying the case with the person that, with all due respect to the lawyers that you've interviewed already, and to my own partners, and who I'm in a great law firm. But I consider Mark Lanier, one of the top, if not the best trial lawyer in the country. And he was one of the 21 firms that gathered together in this multi-district litigation. And so I met Mark about 7 or 8 years ago. I, of course, had heard about him. He and I developed a fantastic relationship. And so the group of lawyers that were involved in the case decided that he and I should try the case together. So, he was clearly the lead. I did a lot of the witnesses. I did most of the workup of the case. Mark came in at the last minute to try the case. And so we tried this case in federal court. So remember, you've got a unanimous jury required. We had 16 jurors. We needed a unanimous of 12. We've spent in the case a total, this is across all defendants, about $150 million in litigation costs.
Just for that particular case?
Well, for all the cases. In this particular case, we spent about $10 million to bring it to trial. Litigation costs, expert costs, et cetera.
And these are expenses that the county and cities aren't paying for. The clients aren't paying for. The lawyers are paying these expenses.
There's no way that Lake and Trumbull County could have afforded to pay the litigation expenses in this case. They were strapped, robbing Peter to pay Paul from one department to another to deal with the epidemic.
So the only way this could get done is with lawyers who had the courage to invest not only their own money, but their time to make a difference. Otherwise, it's never, nothing, there's not going to be a change.
Right. So to get ready for this trial, we reviewed over 50 million documents. Our team put in more than 3 million hours of time in the case.
Incredible.
So we synthesized it all into, basically a double plaintiff bellwether trial. We did community surveys. using jury consultants to figure out how do people feel about their pharmacy. Most people don't realize that pharmacists have what's called a corresponding responsibility to make sure that they're dispensing drugs for a proper medical reason. That corresponding responsibility lies with them as well as the doctors. So they have to set up systems and use their own data to figure out whether there are red flags and that certain people and certain doctors shouldn't be either prescribing or utilizing opioids. So we did that community survey. We figured out, what was the demographics of the type of juror that we wanted. There were 3,000 questionnaires sent out to prospective jurors. It was whittled down to about 150 prior to trial. We ultimately voir dired about 100 jurors. Judge Polster took a very active role in voir dire. We voir dired each juror individually in chambers because might imagine questions about addiction in the family and how they feel about pharma and how they feel about the epidemic, how they feel about treating addicts and that sort of thing are all questions that were really important to ask these prospective jurors.
Were the lawyers allowed to ask questions of the
lawyers were allowed to ask questions. What was kind of unique about the case is that I was the only local lawyer that was involved in the voir dire. Jones Day represented Walmart. A firm from Washington, D.C. represented CVS. And Bartlett Beck from Chicago represented Walgreens. And I was the only local lawyer. So I had, with jury consultants, I had what I would say is a pretty distinct advantage during voir dire. I handled the entire voir dire for our side. And so we ended up with a jury of 16 people from around the region. As you know, in federal court, you draw jurors from 6 or 7 counties, not just Cuyahoga County. And we proceeded into trial. And we tried the case for 7 weeks. And we employed a shadow jury. So that's a linear. That's something that Mark does in all the big cases. So we had a jury consultant who went out and solicited potential jurors. We tried to figure out a demographic for the shadow jury that mirrored the jury that we had as best as we could. And because this was such a prominent case, it was broadcast into another courtroom. And so there were visitors that were allowed to be in our courtroom as well as in another courtroom, and our shadow jury was in the other courtroom.
Incredible.
And the jury consultant would debrief them every night. And then when Mark and I would go back to his hotel room, by about 8 o'clock at night, we had all the information as to how we did that day.
This is incredible. I got to take a step back, Peter, because you start with, before juries even thought about, you do this big data survey. You then go through this really intense process of jury selection. Do you have your consultant with you in chambers during this jury selection process?
Yes, we used 3 jury consultants. We used Mark's. He wasn't in chambers with us. We used Lisa Blue, very nationally prominent jury consultant from Texas. And we used a guy who I've been working with for 30 years that it turns out had worked with Mark Lanier for at least that long, and Robert Hirschhorn. And he was in chambers with us. He's a great friend. He's a premier jury consultant. And yeah, so we He was with us.
Incredible. So then you used a consultant for the jury selection process, and now you actually have a shadow jury to mirror the actual jury, so
That's
that at
correct.
the end of the day, the jury consultant could gather data from this shadow jury, provide that data to you and Mark so that you could use that information to help guide and theme your case each and every day moving forward.
That's right. And we had an additional advantage, and that is the judge allowed jury questions. Now, it was a little bit different than what you might have experienced. Usually, the questions are gathered up at the end of cross-examination, and then the judge asks the questions. In this particular case, the lawyers would gather up the questions from the bailiff. We would confer for a short period of time, and then whoever put on the direct of that witness had to go through the questions and provide the answers as best as the direct examiner could, or have the witness obviously answer the question, or the cross-examiner who could then also cross-examine the witness based upon the questions. During the course of this trial, we had this jury understood the importance of this case and its, likely national prominence. And I think all told, we had about 250 written questions that were answered during the course of this 7-week trial. What did we find out? Our themes were resonating. They were asking questions that I wish I would have asked the particular witness. And so we knew between our shadow jury and between the questions that were being asked that we were doing pretty well during the course of our case in chief, and things got even better during the defendant's case. And then I just want to add one other thing. You talk about jury service and the importance of juries in our system. This jury spent 7 weeks with us during COVID. This is November of 2021, okay? Wearing masks. By the way, trying a case with a jury that has masks on.
Yeah, really
I'm
difficult.
sure you look at juries like I do, you couldn't tell their expressions. But anyway, 7 weeks in trial, they deliberated just on liability. This was just a liability-only case, and we'll talk about that in a second, for 6 days.
It's incredible. They really took their job seriously. That's all you can ask for from a jury.
How did they do that? When we debriefed them, well, one of the jurors was a school teacher, a social studies teacher from Chagrin Falls. She was also a track coach, by the way. And what we found out is that she supervised the deliberations as if she was in class. So she had these big sheets of paper. She would write down all the questions that had to be answered on these big sheets of paper and attach them to the wall. And then she would go through she had the jury go through all the elements with respect to each of the 3 defendants individually. And that's what took 7 days.
Incredible, though. That's really what you want from a juror.
Yes.
Amazing. Peter, you touched on the jury would seem to be resonating to your themes throughout the case. So what were your themes and how did you develop those themes?
So the big thing was foreseeability, Andy. In other words, if you don't have controls over opioids, is the harm to the community likely to occur? And if you know that the epidemic is heating up and you know that you have to control it by controlling volume, How do you do that? And do you have the wherewithal to do that? So the defendants weren't surprised by what was happening because it was all over the newspaper starting in 2001. The question was, what were they doing about it? And they basically lent a blind eye to the whole thing because there was so much money being made. And this is a perfect example of what's wrong with our pharmaceutical industry, that it's a not-for-profit. That it is a for-profit industry as opposed to not-for-profit. And so they basically ignored their obligations. And what they tried to say in trial was, well, as things were getting bad, we tried to put new systems in place. We started to look at our data. We tried to educate our pharmacists better, but it took time. We had to spend money on it. It was part of our budget, and we couldn't get enough money, et cetera. And so don't hold us responsible. It's all the bad doctors and the bad patients that should be held responsible for that. Well, we had an engineer from Swagelock on the jury. And when we debriefed him, and we asked, what resonated with you? He said, well, look, he said, when I design something in my office, because we've learned that there's something dangerous about our product, I don't just design it and then say, like, I've done my job, everything's going to be fine. I go down to the floor and make sure that it's being manufactured properly, and I don't wait months, let alone years and years and years, while the danger is out there associated with my product. So that's just an example of how, we utilized these themes that ultimately persuaded jurors because they understood that from their own perspective, when you are involved in creating a danger, and you have the wherewithal, and it's foreseeable, and you have the wherewithal for correcting it, you don't wait months and years to do that.
It was one of the defense themes, hey, we're just pharmacies. We take orders from doctors. When we receive a script, what are we supposed to do? It's our job to fill a script. We're not there to evaluate whether this is drug-seeking behavior or something else. We get valid scripts, we fill the scripts, that's all we do. Was that part of the defense theme?
Sure it was. The problem with that theme was that, there are registrants under the Controlled Substance Act, excuse me, and they have responsibilities themselves. And one of the responsibilities is to do due diligence with respect to every script and to document it. So I'm sure that, your audience, lawyers and other people who are watching this know that there are times when you present a script, whether it's for an antibiotic or it's for any type of drug, and there's a concern about whether there's a drug interaction because of other drugs you're taking or because there's some danger associated with the script, the pharmacist calls the doctor and says, hey, doc, did you really mean to give this patient 25 pills of 50 milligrams of OxyContin? Isn't 5 or 6 enough? What are you treating them for? So yes, that was a defense, and the defense was, of course, that there was the DEA's fault, it was the FDA's fault, it was the bad doctor's fault, it was the patient's fault, it was criminals' fault, it was cartels' fault. But we had to prove that their conduct was a substantial factor in creating the epidemic, and under Ohio law, they were jointly and severally liable for that. And of course, if there's bad conduct that's foreseeable, that's not a defense. Yeah.
So I'm always fascinated by how lawyers develop themes. And I know you are a master at it. And so is certainly Mark Lanier is as well. I've attended some of his seminars, and he's very good about using analogies. In reading about the case, one of the themes that at least I read about that you and your team used was these pharmacies, it's not a gumball machine. these aren't human vending machines that are just churning out pills for money. And I love that theme. Not a gumball machine, not a vending machine. That's just who came up with that? That's so good.
That's all Mark. That's all Mark. And of course, we had a gumball machine in the courtroom. and one of these old gumball machines that, you put your money in and the piece of gum comes out.
It's so good.
While we're on that, in terms of visuals, as you know, having attended his seminars, he's very big on visuals. On the causation issue about how, to negate this claim that there were lots of other people that are responsible for this. If you've ever been in Judge Polster's courtroom, if you look out the window, there is the Detroit Superior Viaduct Bridge. It's blue, okay? So we kept looking out this window. He said, Pete, tell me about that bridge. I said, well, it's a bridge that connects the east side of the west side. There's thousands of cars that go across this bridge every day. He said, what if we were to create from Legos a model that looked just like this bridge? And he said, what if we were to, on the argument that they didn't contribute to cause this, what if we were to jury rig this bridge so that if you took out one piece of Lego, the bridge collapses?
It's amazing.
All right. So sure enough, we built this model bridge out of Legos, looks just like the bridge that you see from Judge Polster's courtroom. And in closing argument, in rebuttal, after they had said that there were lots of other people responsible, he said in a closing argument, look, when you build a bridge, there are lots of people responsible for designing and building it. And then there are lots of people involved in maintaining the bridge so that people who travel across that bridge every day can be assured that it's going to stand, that it's going to be safe. And all it takes is one of these players to not do their job to cause a catastrophe. And we brought the bridge out in the middle of the closing argument, put it on a table, and he said, just like that bridge, this is what happens if one defendant, one person doesn't do their job. And he removed one of the Lego pieces and the bridge collapsed in front of the jury.
Absolutely incredible. And he came up with that during trial.
Yes.
It's just, who built this Lego, this bridge?
So Mark has two guys, Juan and Jesse, who are both former military guys, and they've run all of his audio-visual work and stuff, and they found somebody to create the model during trial. It's
so incredible. Peter, we've been going at, I could literally talk to you all day about this case. Tell us maybe one or two more things about the trial, and then I have to ask you a closing question to get you out of here, to try to keep this within a reasonable amount of time, because we could talk forever.
Well, it was hard, as much as the defendants wanted to say to the jury that this was just one case, it was hard for them to not have the jury understand that this was a case that had national importance. I mean, look, we were looking at national data, not just Lake and Trumbull County data. We were talking about the federal government and the DEA and all that. And I celebrated the verdict at Johnny's downtown with a couple of my partners. Mark got on his plane, went back to Houston. And then suddenly I started getting emails from the jurors that they had been following what was happening in the paper. We were getting into the second phase of the trial, which was the abatement phase in May of 22, and I was getting emails from the jury, and they want to know how I celebrated. And I said, there's this restaurant downtown at Johnny's, and so we had a nice dinner that night. And they said, well, we're getting together every month as a jury, because, we've made a lot of friendships, and we're going to have a dinner at Johnny's restaurant where we're all going to congregate and celebrate what we did for this country.
Incredible. Are you still in touch with any of the jurors?
Yes.
That is just absolutely amazing. What a great story. And, it's just so people understand, this was a bifurcated, or really a two-phase case. Can you just explain that to our listeners?
Sure. So public nuisance is a legal claim, but it sounds in what's called equity. You can do public nuisance claim and seek legal damages, compensatory past and present and future compensatory damages, or you can ask for injunctive relief. In other words, that the court determine how the defendant should change their conduct, and we got that in this case. And secondly, we can ask for monetary awards in order to abate the epidemic. Those are equitable. That's equitable relief, and so generally the jury doesn't decide equitable relief; they only decided liability, and so that's what we did in this case. We bifurcated the case. They determined liability, and then ultimately in May of 2022 we tried the equitable remedy of abatement and injunctive relief before the court. And the court awarded his verdict at that point.
Amazing. And what was the ultimate verdict, Peter?
So it was $650 million to be shared among Lake and Trumbull County, to be paid out over a 15-year period of time, to be monitored by the court in terms of whether or not it was the expenditures, the money was being properly spent. It obviously had guardrails associated with it. That case went up on appeal. In the meantime, while the case was up on appeal, we settled the national case involving the CVS, Walgreens, and Walmart. They agreed to pay, I think it's about $14.5 or $15 billion. The total settlements that we've reached with all defendants across the distribution chain is about $60 billion paid out over a number of years. It has serious and significant guardrails associated with it. It's not like the tobacco settlement where the monies went into the coffers of government. This is actually almost every state has an abatement trust fund. The subdivisions got some of the money. The state got a small share, about 15%. And then there are these trust funds that where you can apply to be funded for various research, for addiction treatment centers, foster care, et cetera. So that's how it worked. Ultimately, the good news is that the money started flowing about 3 years ago, and the latest statistics from the last 2 years have demonstrated that opioid-related deaths have been reduced in our country by about 35%. So at its height, we were losing more than between 175,000 and 250,000 people per year from opioid-related deaths. That, of course, doesn't count the millions of people that have opioid use disorder. And the epidemiologists, including the one that we use in this case, have told us that if you look at opioid-related deaths, which are reportable, you can extrapolate that, and to the extent they're being reduced, you can extrapolate from that how successful you are in treating people with opioid use disorder. And so, I think it's working. Obviously, we're proud of the impact that we've had, And it's just a perfect example of how the judicial system does work in really great ways.
Yeah, that's such an incredible ending to an amazing case, an amazing trial, and an amazing group of lawyers who risk their own time and money to make a difference. And congratulations to you. Congratulations to your team. I so much enjoyed this. I cannot let you go, Peter, without asking this question, which is what I ask of all my guests. You are truly one of the premier lawyers, not just in Ohio, but across the country. Can you give some advice or guidance to younger lawyers who want to handle these big, mass, complex cases?
You know, it's in many ways is different than handling the single event case. In many ways, it's the same. So, you know, when we're representing a client in a personal injury case, whether it's an auto accident case, a medical malpractice case, or a product liability case, you know, we're obtaining justice for that individual. But oftentimes our cases, indeed the jury verdicts that we get, particularly, you know, set rules of conduct way beyond the individual case. And so I've always been proud of the fact, setting aside mass torts, that our cases, Andy, your and my cases, make a difference not only for the individual, but for our society in general. And to then have the ability to have a direct impact in a large, complex case like that, of course, is a real honor and a privilege. And so my point is that, you know, whether you're a single lawyer law office or a larger law firm with a bunch of lawyers or great trial lawyers, you can make a difference. And your success not only provides you a nice standard of living for yourself, but it allows you to then invest in other cases that can make a difference to not only other people, but people across our society. And I think, you know, I've been doing this for 50 years. I couldn't be prouder of what it is that we as trial lawyers do for our country. And to get a little bit of recognition for what we do is great, but we know ourselves how important a role that we play in making sure that you know, products are safer, and using our justice system and our juries to make sure that that happens.
100%. So well said. Peter, I just loved this conversation. Thank you for doing this.
Andy, by the way, thank you for everything that you're doing. I've watched all of your podcasts. You're doing a great thing for our community, and you do a great job in interviewing lawyers like me. And so keep up the great work.
I appreciate you saying that. It means a lot. Thank you.